It took us a bit to get that going. I appreciate that. Thanks for bearing with us. My name is Joshua Christian. I am a staff attorney with the Eviction Defense Center at the Legal Aid Foundation of Los Angeles. I am gonna today be going over some of the COVID-19 eviction protections that are available in the county. As we all know, the protections have been changing rapidly over the last few months, and the foundation just wanted to touch base with the community, make sure that tenants are empowered. You're gonna hear me come back a few times and advise you, hey, regarding your individual case, reach out to us, let us look at your individual case, but for now, I'm just gonna go over broadly the protections available. So first, I'll explain who we are, how to contact us if you're not familiar. Then I will be talking about the various emergency protections that are available to tenants. First, the CDC federal level orders. Second, the state protections from the state California legislature. Then I will be hitting on the LA County emergency order that now extends across the county. And then I will be going over very briefly the local protections that are still in place. Okay, who are we? Since 1929, the Legal Aid Foundation has provided civil legal services to poor and low-income people in LA County. We helped more than 100,000 folks in 2018 alone. We have 5 offices throughout LA County. We run several clinics, self-help centers. Right now, we do have COVID-19 protections in place, so we advise you, give us a call, visit our website, and reach out. We provide civil legal services in various areas, in domestic violence, in employment law. You can see the list here. Most importantly today is eviction defense, which is my area of law. I will also mention that LAFLA is part of the Right to Housing Coalition, which is a group of legal services organizations and tenant organizers which ensure universal access to eviction. Eviction defense lawyers for tenants who can't afford them on their own. If you are facing an eviction, go to stayhousedla.org, see if you qualify and get referred to us or a partner org. So that's us. I would like now to go over the various protections that are available during this pandemic. Primarily, there are federal government protections, there are state California protections, and there are local protections, largely at the county level, that extend to every Angelino within our county. I'm going to begin with the federal order. The reason for that is that the federal order is kind of a last resort. I'm gonna discuss it and then I'm gonna kind of toss it aside. It is a safety net underneath tenants. It applies in all cases related to non-payment, cases related to other things, but it does require a very specific certification of an inability to pay rent. It prevents all actions to evict, but then it states 5 exemptions that are excluded from those protections. So you can see there are kind of some gaps in these CDC protections, and in general, the county and the state have applied protections that are more broad and thorough than what the federal government is supplying right now. There are in the CDC order, if you are covered, some serious criminal penalties. As I said, this is kind of a bottom line. In general, LA County, state, local protections have broader and stronger protections for you. We encourage people, look, if you are considering taking advantage of the CDC order, reach out to an attorney, call LAFLA, call Stay Housed LA, go to that website and check to see if that is the best option for you. These are the details of the order. As you can see, there are 5 exemptions here that take tenants out of applicability. There are 5 things that a tenant needs to attest to make sure that they are underneath the order. So it's broadly worded, but then it states a bunch of exemptions for you. So there will be a few situations where the CDC kind of is a safety net because a tenant has fallen in between the state and local protections, but these are few and far between. It most commonly is going to apply to folks that are facing a notice to vacate from the sheriff. So what's called a writ of execution has been issued by the court, and a tenant is facing actual imminent expulsion from their home. Either way, reach out to LAFLA, go to Stay Housed, and check to see if this 5-part certification is really the best option for you. Okay, so that's federal law. Now we're going into the big one. The California COVID-19 Tenant Relief Act, or Assembly Bill 3088, AB 3088, which you'll hear me refer to kind of interchangeably as one or the other of those things. AB 3088 provides protections for eviction, primarily for tenants who were not able to pay rent between March 2020 and January 2021. There are other provisions here. A landlord can't evict you without just cause. A tenant has to send a declaration to the landlord of their inability to pay. Also, a 3-day notice has to be a 15-day notice. I'm going to go through all these in detail as we go on. There are also, just to mention, there are increased penalties for a landlord that retaliates against or harasses a tenant that's taking advantage of these rights. Again, come to us, consult a lawyer, figure out about your individual case. So here's the big thing about the COVID Tenant Relief Act. What the Relief Act permits is for you to change a large amount of your rent that has arisen during the pandemic from rental debt to consumer debt. That's a big deal because the distinction between these two things is that rental debt can be the basis for an eviction. Rental debt is when your rent is not paid, your landlord can take you to eviction court. This is an ordinary issue outside of the pandemic. Now, under AB 3088, subject to certain conditions, you can change your rental debt to consumer debt. What that means is that your rental debt is no longer the basis for an eviction. It is a bill, like a medical bill or a bill for a car that you've purchased. You owe it to your landlord. If you don't pay, your landlord can sue you in small claims court, but it can't be the basis for eviction. That's a big deal. So let me go through the conditions that you need to meet here. So the very first thing, you need to declare to your landlord that you are covered by the Tenant Relief Act. Now, the certification that you need to send is relatively simple, but it is very specific. Now, I say go to LAFLA's website, check for the document that we've posted. There is a sample of this declaration that you can send, but once you've sent that declaration, you are covered. Now, as a covered person, how are you going to convert your rental debt to consumer debt? Now, the timeline here is split into 2 parts. And remember, I said this is a complicated law. From March to August 2020, that debt becomes consumer debt, period. You send that declaration to your landlord. You say, I am impacted by COVID. For that reason, I cannot pay my rent this month. And when you send that, March to August becomes consumer debt, period. It's from September to January that these become a little bit more complicated. From September to January, you will owe, by the end of January, 25% of the rent that was due between September and January. But as long as you make that payment, the rest of your debt will become consumer debt. So how does this work? you need to make 25% payment of the rent that accrues between September and January. That debt does not need to be paid on a month-by-month basis. So there is confusion among landlords, tenants. There's confusion about whether or not someone needs to pay 25% of their rent every month. September, 25, October, 25, November, 25. No, by January 31st, you need to make a payment of 25% of all of the rental debt that came up from during those 5 months. As long as you do that, the rest of your rental debt will become consumer debt. So that one payment needs to be made. It can be a lump sum, it can be on January 31st, but it needs to be paid, and then the rest becomes consumer debt. It cannot be the basis for eviction. Your landlord can sue you, and it's like a bill, but it's not something that will make you lose your housing, which is very important for folks that use diagrams or visual, which I am. As you can see, there are the two timelines, the March through August, where all you need to do is certify to your landlord with this specific but simple declaration that's on LAFLA's website that you are impacted by COVID-19, and that's why you can't pay your rent for that period. Through September and January, you supply a declaration to your landlord, but in addition to that, you need to make a 25% payment by the end of January, not monthly, but by the end of January. Then you are covered, and the rest of that rent becomes consumer debt. So a more specific review, there are important other protections in this law. All notices to pay or quit for COVID rental debt, so that's between March 2020 and January 2021, any notice to pay or quit for that rent must give 15 days to pay, not 3 like would be ordinary outside of this pandemic and these laws that have been passed, but a 15-day notice. And so your landlord needs to give you 15 days to pay. And at the same time, he needs to send you that form that we discussed that's available on LAFLA's site. And you have the option to send that form back to your landlord to certify within those 15 days. And then, just as we discussed, your March through August becomes consumer debt. Your September through January needs a 25% payment. But the point is, you're a covered tenant. You have 15 days to send that declaration to be covered. And then you have all those options available to you. Remember that your landlord can come after you for that amount of money. It's just he can't come after your housing. So it's like a bill, but it's not a basis for eviction. So the bottom line for these things, number one, AB 3088 provides better non-payment protections than the Cdc order, which will delay your eviction to January. It requires a much more specific certification, but those protections are not as good as the protections under state law. State law allows you to convert your rental debt to consumer debt, which is a big deal. And it just becomes a bill that you need to pay, okay? Also, very importantly, there were all these local protections that were in place over the summer that went into September that might even be in place now. Those local protections have a very complicated relationship with the state law. And regardless of how they might work and what protections might still exist for you, you need to comply with the state law in order to be covered by the state law. So we urge people, do your best to comply with AB 3088, which is the COVID-19 Tenant Relief Act, to send that certification to pay that 25% in January, because only then do you get that rental debt to consumer debt conversion. Okay, now, the state law was mainly related to non-payment evictions, to people who couldn't pay their rent, specifically because of the pandemic. LA County has an emergency order that is effective beginning March 4th and going through November 30th that has protections that are not related to non-payment. There are non-payment protections too, but the most important protections right now in the county's emergency order are about evictions that aren't related to rent. And the LA County emergency order extends across the county. So regardless of where you live, if you're in the city of LA, if you're in Long Beach, if you're in Whittier, doesn't matter. The LA County Board of Supervisors has extended these protections to everyone in the county as long as those county protections are stronger than what you have in place in your local jurisdiction. Okay, so in order to avail yourself of the county protections, you also need to certify to your landlord that you've been impacted by COVID-19. And in order to do that, you send your landlord a written notice within 7 days of when the rent comes due. Okay? This applies to commercial and residential tenants, but the most important thing is that LA County has protections against no-fault evictions. And evictions for certain causes that are at fault, but that are not related to non-payment. So a no-fault eviction is a 60-day notice. It's a notice that your landlord gives you in a situation where you haven't done anything. A landlord will give you a 60-day notice that says, for no reason, we want you out, period. A landlord in a rent control jurisdiction might say, I'm moving in my brother, you need to go, here's 60 days, even though your apartment is rent controlled, sorry. But what LA County has said is that you as a tenant need to have done something affirmatively that gives your landlord the grounds to evict you. Unless you did something that placed you at fault, your landlord cannot evict you. And that's really important. Going beyond that, the county has also said, you know what? Non-payment of rent is something that a tenant fails to do. That's an at-fault eviction. The state law and the local law deal with that. But we say that there are other grounds that would be at-fault grounds to evict a tenant that don't apply in the county of Los Angeles. And those grounds are for unauthorized pets, unauthorized occupants, or a nuisance that are caused by COVID. So let's say your cousin moves into your place and your landlord comes after you, sends you a 3-day notice and says, your cousin needs to get out, you're violating your lease, we demand that that person leaves. Well, if you certify to your landlord that you're impacted by COVID, that eviction is not valid. You are protected from that because why is your cousin still there? Well, you can't throw them out onto the street because there's a pandemic. There are safety measures in place. So LA County has these extra protections for no-fault evictions and at-fault, particular at-fault evictions when a tenant is impacted by COVID. So there are also other local protections, and we saw these just explode over the spring and the summer. There are protections in LA City, I mentioned Long Beach, in the city of Whittier. All these different places enacted their own ordinances that could protect tenants in certain situations. This is a complicated issue. In general, the county protections are going to apply to you no matter where you live. As long as the county's protections are stronger than the local protections that are in place, then that floor is going to apply to you. And I'm not going to go through Long Beach, through LA City, through Whittier, through all these places. In every jurisdiction, consult a lawyer. Come to LAFLA, come to Stay Housed. Ask about your individual area, what is going to protect you there. There are complicated interactions between these laws. There are non-payment provisions that might affect the state law, but consult about your individual case. What you know for certain is that the state law in California protects you from non-payment evictions, and the county law in LA protects you from no-fault and certain at-fault evictions. Those are across the board. So for CDC, for local protections, call us up and we can give advice on your individual case. So let's do a quick review of what we've learned here. The state of California has provided protections against non-payment evictions. Those are primary. And those non-payment protections might work in complement with local laws. There might be slightly bigger protections under local law, but complying with state law is essential if you can. If you want to know how your local law interacts with the state law, contact an attorney. Next, we have LA County and other local ordinances. And those bar no-fault evictions, where you haven't done something to justify being expelled from your home. And these certain other grounds, nuisance, pets, unauthorized occupants, if it's related to COVID, you can't be evicted for these reasons. Now, again, these complement the state protections. You should consult with us, but those local protections are important and available everywhere. Last is the CDC order. The CDC order is a last resort. There is a complex declaration involved. It will only delay your eviction. But although there are cases, regardless, that will fall in between the cracks, between the county law, between the state law, and talk to an attorney, say, look, is it the federal government that should be protecting me in this case? Bottom line, comply with state law if you can. If your landlord comes after you for no fault, for nuisance, the county will protect you, right? If neither of those applies to you, the federal government could protect you, but consult with an attorney. Contact LAFLA, contact our website, stayhousedla.org. Find an attorney to give you advice. And this is our contact information. On the left side is LAFLA's access, our hotline, our online help, self-help clinics. We are still holding clinics despite the COVID protections. In general, go to the website, go to the hotline. Those are going to be the best places for you to find us right now because our offices are closed. You can also contact the Right to Housing Coalition, Stay Housed LA. I'm sorry, that should be a D, Stay Housed LA, or call them and see, you get in contact with an organization and get an attorney to advise you. Okay, I will do my best to take your questions here. So everyone is welcome to throw out questions. I will do my best to address general questions. If you have individual circumstances, then we will likely refer you to our hotline and say, hey, check with LAFLA, talk to an individual advocate, specialist, attorney. And right now, feel free to drop anything in the chat. I will say I'm not tech savvy, if you couldn't tell at the beginning, and I don't see the Facebook chat here, so I might ask someone to send them to me off to the side. And that's what we'll do. I will put up our contact info here. Oh, here we go. Okay, so we had a great question. I hope I'm still live here. Uh, Catherine in the chat asked, if my cousin is staying with me now in October and November, can my landlord evict me because my cousin is not on the lease? And Catherine is in LA County. And so the answer is, as long as you certify to your landlord that there's a nexus between COVID and the unauthorized occupant, no. Now, this might get a little complicated because LA County requires you to notify your landlord in writing within 7 days of rent coming due. Now, whether or not that applies to unauthorized occupants, it's a little unclear. Probably not, but I would certify to your landlord and I'd consult with us about your individual case. But it does need to be connected with the COVID-19 virus. But the idea is you shouldn't need to expel someone when it's going to damage public health and safety. Katz asks, what would happen after we pay the 25% at the end of January? That is a great fundamental question. So when you pay, so first of all, let me be clear. The 25% is 25% of the rent owed from September to January. So let's say you pay $1,000 in rent per month, which is not that much for LA, but, and let's say in July, you lost your job and due to the pandemic and you're not able to pay that rent anymore. You can certify to your landlord with that declaration, I've been impacted by the virus. That's the reason I can't pay my rent. So you can do that anytime since September. What happens then is July and August become consumer debt, period. That's that first period that I indicated. Those are no longer a basis for eviction. Now, between September and January, you need to pay the 25%. So that's $5,000 total. If you bear with some math, 25% is $1,250. So Katz is going to owe the landlord $1,250 by the end of January. When that payment is made, the rest of that $5,000 is consumer debt. Just like March through August, your landlord can come after you for that like it's a bill. And depending on where you live and what local jurisdiction you're in, he can sue you in small claims, and there's a complicated issue about when he can come after you, and that's why we say call us. I can't go over every situation there, but as long as you make that $1,250 payment in the hypothetical, the 25% payment, September through January is consumer debt. So hopefully that answers the question. Now, what's important to note is that if that payment is not made, then there will be no conversion. So let's say you only pay your landlord $1,000 after you've been trying pretty bad, then your landlord can say, hey, look, there's $4,000 left over, and that's not consumer debt anymore. I can go after you in eviction court for that. So we've got another one. Katz, thank you. I really appreciate having these questions to answer, and I hope that they'll be applicable, when other people come in and take a look. So as of right now, these state protections end on January 31st. On February 1st, everything's back to normal. So your ordinary rent will be due February 1st. So $1,000 a month, you only pay $900 on February 1st. Your landlord can come after you with a 3-day notice for that extra $100. Hey, Katz, you caught me just before I logged off. So I think, let me scroll back. You said, so as I said, so this is going to depend where you live, right? If you're in the city of LA, you could defer that rent even later. And these are complex questions. So you're really getting into the weeds on this one, and that's fine. That's why I like being an attorney, is the weeds. So basically, if the city of LA is still in a state of emergency, the city of LA's ordinance permits you to defer your rent all the way when that state of emergency is in place. So if you've notified your landlord you're COVID impacted, which you need to do under the LA ordinance, then you can continue deferring your rent if LA City is still in that declaration of emergency, or there's a local declaration of emergency. Now, what would happen because you hadn't paid the 25% is that you would kind of downshift. You would not get the AB 3088 protections. So your rental debt wouldn't convert into consumer debt. And so your March through August would convert, but the September through January would still be rental debt. And that rental debt would become due a year after the emergency ends. It's or actually March 1st, 2022. It's so complicated. You should call our line. The local ordinances versus the county ordinances versus AB 3088. You're hitting all three, and it's a big one. So basically, like I said, you would downshift to rent deferment. You would all that rent would stay the basis for eviction, but you would have a longer deferment period to 2022. So this is one of those things where in the presentation, it said, your local jurisdiction could give you greater protections than the county, even than the state, but only in these very specific instances. So that's why, call us up. That's why I can say to everybody, go to Stay Housed LA, call LAFLA, go to our website, apply for services, and we're there to help and to go through these complicated cases with you, because it's crazy for everybody. And thank you. That's a great question. Thank you.